and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi, everyone.
Now, this is the last podcast before we break for the summer, so let's make it a good one. Dennis, what's first on your agenda?
Well, it's artificial intelligence. Legislation is emerging on this, and the ICO has published guidance. So let's take a closer look at what's happening.
Artificial intelligence is to governance lawyers what driverless cars are to insurance underwriters, a potential headache and a potential risk. Bulk automated decision-making may have many attractions for finance directors whose focus is always the bottom line. But lawyers, and especially monitoring officers, need to be concerned with the quality of the decisions that are being made by those processes, what we call nowadays good governance. The dangers are simple to state, but the solutions less so. At the heart of the matter is how to ensure that pre-programmed decision-making is consistently fair and accurate, and yields the right decisions in the situations to which the automated process is applied. But there is important news this week. Artificial intelligence systems will have to identify a legal person to be held responsible for any problems under the proposals for regulating AI unveiled by the government last week. The proposals were published as the Data Protection and Digital Information Bill, which sets out a new independent data protection regime. The measure will be debated in detail after the summer recess. The core principles of AI regulation proposed last week will require both developers and users to comply with the following 6 requirements. 1, to ensure that AI is used safely. 2, to ensure that AI is technically secure and functions as designed. 3, to make sure that AI is appropriately transparent and explainable. 4, to consider fairness in the administration of the process. 5, to identify a legal person to be responsible for AI. And finally, 6, to clarify routes to redress or contestability. Now, regulators will include the Information Commissioner's Office. Their role will be to interpret and implement the principles which underpin the new legislation. And elsewhere in the bulletin, there is a post from the ICO setting out the current guidance on the use of AI systems in decision-making. And of course, LLG will be following this topic over the coming months.
Now, one for our CILEx members who are no doubt acutely aware of the breaking news last week that its regulator might now be moving away from CILEx Regulation over to the Solicitors Regulation Authority. Talks are about to start to, quote, explore a possible proposal to transfer the regulation of its members. CILEx said this is necessary due to the number and variety of models involved in the regulation of legal services, which can, it says, be confusing for customers and professionals alike, adding that regulation needs to help build understanding and confidence as to the choice of legal professionals available. Back in February, CILEx embarked on a case for change review and recently asked Chris Kenny, the original Chief Executive of the Legal Services Board, to consider the quality of evidence which lies behind the case for change paper to help enable the board to decide whether to progress to a more formal review. This was published on the 16th of July and broadly agreed with the case for change. CILEx Regulation, however, are not impressed, stating that in their view, quote, CILEx's actions are not compliant with the requirement of the Legal Services Act 2007 and the relevant delegated legislation. Its objectives are those of a representative body. CRL rejects the opinions expressed in CILEx's review. There's no basis to suggest, as it does, that CRL has viability challenges and will have a higher unit cost than other regulators. The cost to those CILEx represents is, in any event, they say, only one element of the public interest for which CRL is responsible. Now, the Law Gazette, unsurprisingly, runs with an article raising concerns about the status of solicitors. This is certainly one to watch, and we will continue to stay close to developments, ever mindful of our members who are affected. In other news, Dennis, I've noticed that quite a number of councils are returning to the committee system. What can you tell us about this?
Helen, yes. Bristol is the latest to change. Here's what we know so far.
Bristol City Council is to consult the public on how it should implement a referendum decision to drop its elected mayor model and revert to a council with a committee system. Residents in May voted to scrap the current mayoral system, which had been in place since a previous referendum in 2012. The council has established a cross-party working group to develop the committee model of governance, and which will report back to full council before the end of the year. This working group will develop the design principles for the structure of the new committee model, including the functions of full council, terms of reference of the committees, and the new officer scheme of delegation. It is expected to seek to learn from the experience of other councils that have already reverted to the committee system, which councils have been permitted to do since the Localism Act 2011. Sheffield City Council has moved to the committee system following a referendum last year, although it previously had a leader and cabinet system rather than a mayor. Hartlepool Borough Council, which abolished its elected mayoralty in 2013, has also since adopted a committee system. And some small districts were allowed to keep the committee system by the Local Government Act 2000 and have never had cabinet governance. Other councils that have reverted to committee governance include Kingston upon Thames, Wirral, Reading, Brighton and Hove, Newark and Sherwood, and Cheshire East. But here's the question. Why are councils doing this when it is both clear from recent Devo deals and also the recent Levelling Up paper that government really does prefer to deal with mayors? Now, LLG are already over this topic, with intelligence suggesting that some changes are motivated by the sharing of power where political administrations are split. But there are a range of other considerations too. And if your council is considering a similar change, let us know via the forum page on our new website.
Thank you, Dennis. In other news, social mobility is currently a hot topic. Tell us more, Dennis.
It appears, Helen, that opinions do diverge about the nature of ambition and whether you should be limited in your career aims and choices. Here's what some people are reported as saying.
One of my favourite Law Society Gazette contributors is Edouard Reyes. I've had the privilege to work with him on one of his roundtable events. But this week, he's picked upon a controversial issue on social mobility, and it's very concerning. Why should our ambitions be limited by class or colour, or indeed any other aspect of our background? Reyes quite rightly challenges those who say that you should limit your ambitions by taking a step at a time and aiming for the ceiling that you know exists rather than reaching for the sky. So, who exactly is suggesting don't reach for the sky, just aim for the ceiling? Well, for one, the government's new social mobility czar, Catherine Birbalsingh. Birbalsingh's appointment last month saw the former teacher living up to her reputation for controversy. Working class people, the Oxford graduate said, should aim lower than going to Oxbridge. Poor children, she says, should take smaller steps rather than aiming straight for elite universities. According to the Gazette article by Reyes, there are a number of other luminaries who take a gradualist approach to the ambitions of others. Yet the research that proves that diverse organisations do better and diverse boardrooms make better decisions is detailed, extensive and credible. That's why Cambridge colleges won't thank Birbalsingh for telling clever students from poor backgrounds to apply elsewhere. They, in fact, actually hope to attract such students. It is why city law firms with uneven success are now putting serious effort into attracting, retaining and progressing to partnership underrepresented groups. And it's also why the judiciary believes it needs to do better with regard to the imbalance seen in its senior ranks. So, if you're a young trainee or solicitor thinking about your own future and you feel that your background places you at a disadvantage in your career, then my advice to you is simply this. Do not be deterred by those who might seek to discourage you from achieving what you want to do based upon your background, how much you own, or your origin.
Now, taken from the LGA Bulletin, it's been reported that Citizens Advice issued around 700 food bank referrals a day last month. compared with 400 a day during the same period last year. Councillor Andrew Weston, chair of the LGA's Resources Board, said, "Councils have been at the forefront of helping their residents through the current crisis by providing advice and financial support, including making referrals and allocating funding to food banks." However, a new survey by the Association of Directors of Adult Social Services of its members is warning that the rapidly rising cost of basic things is making already challenging conditions in social care much worse. Almost 3/4 of social care directors in England responding to the survey are reporting increasing requests for help. And finally, the Law Gazette reports that the latest judicial diversity statistics continue to paint a bleak picture for solicitors, with the percentage of non-barristers in post lower than it was in 2014. Further, that only 1% of judges are black, a figure that's not changed since 2014, while 5% of judges are Asian. The Law Society remains concerned about the significant disparity in outcomes between ethnic minority and white candidates, and for solicitor candidates compared with barristers. Society President I. Stephanie Boyce said, "We believe the Judicial Diversity Forum should now explore reasons for leaving the judiciary in light of the worrying number of solicitors leaving the bench. This could have a knock-on effect on the overall diversity of our judiciary." And on that note, that's it for another edition of the podcast. You can read more on that, the items discussed today, and many more besides by going to bulletin number 27, available now on the LLG website. We'll be back in September, but until then, it's goodbye from me.
And from me too.
Thank you for listening. Have a good week, everyone.